without going into that fact about that 4/5/2012 order, which is not on record, either here before this court or before the learned courts will in the restoration. Even assuming on this impugned order has been passed because of non-compliance of the order, thereafter 3 dates have passed. If for a moment, if I am just allowed to show this page 34, 19/8/2015 order, page 32, by page 32, the first order is there, the last line of 19/8/2015, which is the reason for हाजिरी दी गई, वादी दिनांक 19/7 का पालन करें, वाद दिनांक प्रतिवादी को उपस्थित हो, then 23/11 वादी और प्रतिवादी के वकालतन हाजिर वादी एवं पूर्व आदेश का पालन करें, वाद दिनांक 9/12 प्रतिवादी की उपस्थिति हो, and thereafter this impugned order has been passed. Even if one last opportunity would have been given, considering the matter that the reasonings are that till date in the order impugned, the reasoning is that till date no step has been taken by the plaintiffs for the appearance of remaining defendant. It seems that the plaintiffs are not interested in the prosecution of the present suit. Hence, the suit is thereby dismissed.
Where is the plaint?
The plaint is not part of the record. The
चल।
plaint is not there.
नहीं सकेंगे।
I have a copy of the plaint.
नहीं सकेंगे। आप लोग से एकदम सच।
ये क्या था? It was order 9 rule 2, the impact of order 9. How it is.
You have to say anything.
One more thing, if this honorable court thinks proper,
then
subject to some cost, this suit may be restored subject to payment of certain cost. And
WPC number 4253 of 2017 for the learned counsels appearing on behalf of the parties. This writ petition has been filed under Article 227 of the Constitution of India for the following reasons. They are: A. Order dated 9/12/2015, by which the plaintiffs did not take any steps for appearance of the remaining defendants. 4/5/2017, whereby the civil miscellaneous case number 1 of 2016 was dismissed on the ground that in spite of duration of the suit and for recall of order dated 9/12/2015, correct?
yes,
Has been dismissed. By which the application for restoration of the suit was dismissed by civil miscellaneous number 1 of 2016. The learned counsel appearing on behalf of the petitioner by assailing all the 3 orders has submitted that the provision of order Rule 2 has to be exercised cautiously, wisely, and with circumspection, and the discretion, and the word may has been used in the said provision. He submits that In the present case, the in the suit by the order dated 19/8/2015, the plaintiff was directed to take proper of the substituted dependents on 8/9/2015, and there were thereafter 3 dates, that is 8/9/2015, 3/10/2015, and 23/11/2015, and ultimately the suit itself was dismissed by order dated 9/12/2015 on account of non-compliance of the order dated 19/8/2015. As may be fixed by this court, and also subject to payment of any cost which may be see online Delhi 98 New Bank of India versus Sunil Dua, and has referred to paragraph 4 reported in ILR bracket 2019 bracket close MP 1842. Paragraph 11 to submit that the term may used in or Rule 2 of Order 9 of CPC has been duly considered by the High Court. And on account of such default, the learned counsel submits that a petition for restoration of the suit was also filed, which was dismissed by the order dated 4/5/2017, although there was no negligence on the part of the petitioner, and another petition being civil miscellaneous case number 3 of 2017 was also dismissed by the third impugned order dated 16/6/2017. He submits that all the impugned orders call for interference considering the facts and circumstances of this case. That is all. The learned counsel appearing on behalf of the respondents has opposed the prayer and has submitted that the discretion of power by the court in dismissing the suit on 9/12/2015 is proper exercise of discretion. The negligence of the petitioner or the plaintiff is further apparent from the fact that even the petition seeking restoration of the suit was barred by limitation, and the plaintiff did not take any steps for filing the petition for condonation of delay. Consequently, the petition for restoration was also dismissed. Thereafter, the plaintiffs again filed a miscellaneous petition number 3 of 2017 for recall of the order dated 4/5/2017 and also 9/12 and also 9/12/2015 without giving any cogent reason for non-compliance of orders, and the same has been dismissed by the third impugned order dated 16/6/2017. He submits that all the orders reflect due application of mind and sound exercise of discretion, and therefore these orders do not call for any interference under Article 227 of the Constitution. 227 of the Constitution of India, he submits that as per the provision of law, the suit having been dismissed for default, the plaintiffs still have a remedy to file a fresh suit. Right? This court finds that although the plaint of the suit has not been annexed with the writ petition, but as per para 7, the plaintiffs had filed the suit in the year 2008 before the learned municip at Lonagarh for number 20 of 2008. As per the writ petition, the defendant number 1 to 4 were the contesting defendants, and the defendant number 1, namely Chamra Sahu, died, and a petition was filed for substitution, being with his legal heirs being defendant number 1 within bracket A to 1 within bracket D. By order dated 19/8/2015, it appears that a petition was filed for substitution of defendant number 3 also, but the petition for substitution was rejected. The order by which the substitution of defendant number 3 was rejected is not under challenge in the present proceedings. However, the next date in the matter was fixed on 8/9/2015 for appearance of the substituted defendants number 1A to 1D. Thereafter, on 8/9/2015, thereafter there were 3 dates on 8/9/2015, 3/10/2015, and 23/11/2015, and specific orders were passed on 3/10/2015 and also on 23/11/2015, directing the plaintiff to comply the earlier order, that is order dated 19/8/2015. But in spite of repeated opportunities, the plaintiff did not take any steps in connection with the defendant number 1A to 1D, and ultimately by the order dated 9/12/2015, these steps for compliance of order dated 19/8/2015 and no steps were taken for appearance of the remaining defendants, and ultimately the case was dismissed, and the court recorded that it appeared that the plaintiffs were not interested in the prosecution of the suit, and the suit was dismissed in default for non-prosecution under Order 9, Rule 2 of CPC. It further appears that by order dated 9/12/2015, it further appears that a civil miscellaneous petition number 1 of 2016 was filed before the learned court for restoration of the suit, which was dismissed by order, and the petition for restoration was also dismissed by order dated 4/5/2015, 4/5/2017 by observing that on 25/1/2016 the petition was filed, and on 1/2/2016 it was ordered to, an order was passed to file limitation petition. Thereafter the applicant who was the plaintiff who was the applicant in civil miscellaneous number 1 of 2016 never appeared before the court for hearing, and the case was dismissed. Further, another petition being civil miscellaneous case number 3 of 2017 was filed for recall of order dated 9/12/2015/4/5/2017, stating that the plaintiff was not negligent in conducting the case. The same was again dismissed by the order dated 16/6/2017. By referring to the submissions made by the plaintiff that they were not negligent was not correct. This court finds that not only the order dated 9/12/2015 was passed after giving repeated opportunity to the plaintiff to comply the order of the court, and by recording that it appeared that the plaintiff was not interested. But even the petition seeking restoration was dismissed on account of non-appearance and negligence on the side of from the side of the plaintiff, and the petition for limitation was also not filed. Thereafter, another petition was filed being civil miscellaneous number 3 of 2017 for recall of both the orders, that is 4/5/2017 and the order dated 9/12/2015, by stating that there was no negligence on the part of the plaintiff. The learned court ultimately rejected the state petition by stating that the stand taken by the plaintiff in the petition seeking recall of both the orders was also not correct and recorded that the plaintiff had made false submission before the court. It also recorded that the reason for absence was also not given in the petition, which was numbered as civil miscellaneous case number 3 of 2017. This court finds that the manner in which the case was conducted before the court, being title suit number 20 of 2008 and the subsequent petitions being civil miscellaneous case in the and they have completely neglected the orders passed by the court, which ultimately led to dismissal of the suit and also dismissal of the petition seeking restoration, which was also barred by limitation, and no petition for condonation or delay was filed. This court finds that the learned court has exercised sound discretion while passing the impugned orders, and this court finds no illegality or perversity calling for any interference against these orders under Article 227 of the Constitution of India. So far as the judgment relied upon by the petitioner reported in 1988 SCC Online Delhi 98 is concerned, the jurisdiction to dismiss a suit under Order 9 Rule 2 must always be exercised cautiously, wisely, and with good circumspection is not in dispute. But in the said case, the court considered the facts and recorded that the appropriate order was passed by High Court in the case of Ram Kishore Tiwari Sutra. Similar view was taken by the High Court, and in the said case, the suit was dismissed on 21/9/2015, and the application for restoration was filed immediately on the next day, that is 22/9/2015. And this fact itself was the reason to record that, in the opinion of the court, in the present case, even the petition seeking restoration of the suit was barred by limitation, and the petition for restoration was also, and the plaintiff continued to be negligent while pursuing his petition for restoration, and there was no explanation, much less any cogent explanation for non-compliance of the orders passed by the court, which led to passing of the impugned orders. This court finds the aforesaid judgments clearly distinguishable on facts, and accordingly there is no merit in this petition, which is hereby dismissed.
Okay.
Yes, there is one passover matter.
Yes. Password is item 7, WPC 2462 of 2016.
I've gone through the order leadership. I was only playing one short play leadership that they may be permitted some short times so they can bring on record the said
Not
document.
required. Not required. We will take it on record. Jhoot बोलेंगे तो we will take care of that. Don't worry.
They'll serve me a copy or something.
You provide them. You see, whatever is, you have already issued notice to them.
Yes.
for taking the compensation amount?
Yes. Award has
If
been
they have award has been prepared, what is the date of the award?
Annexure A and
Give me the date,
B. First,
please.
first.
Annexure A, 22/11.
22/11.
This year,
This month.
this month, 22/11/24 is the award in the name of the petitioners.
Present petitioner.
In the name of is the original
Original petitioner.
petitioner's
Father of-
father.
Petitioner's father. Okay. This is amount is 48.99.
337.
99 337, right? And
And
you have
second-
issued notice to him,
Petitioner.
to Kishore, this Kishore Kujur is the petitioner,
Prem.
okay, for accepting the award,
For verification of document and accepting.
for verification of document and accepting
and giving.
document and accept. If he has any further objection, he can raise it
Yes.
as per law.
As per the law.
He may not accept the entire, he may say that he has more amount to be
He
paid.
can object and according
As
to
per
the
law.
Compensation Act, he can proceed.
That's right.
Then no issue.
The learner to the order dated 12th of August 24, 12th of August 24, and has submitted that as per the earlier supplementary counter affidavit, a stand was taken that the award in connection with the property of the present petition of the original writ petitioner will be prepared, and today he has furnished documents to show that award in the name of the father of the petitioner, who was the original writ petitioner before this court, has been prepared for on 22/11/2024 for an amount of rupees 48,99,337. He submits that a letter has been issued to the petitioner for the purposes of producing the documents so that the documents can be verified and the amount of compensation can be paid. He submits that the petitioner may approach the District Land Acquisition Officer Ranchi for the needful, and the writ petition may be disposed of. The learned counsel for the petitioner submits that he has no up-to-date instructions from the instruction here.
No issue.
He has no up-to-date instruction in this connection, but if the letter has been issued, the same may be taken on record. The documents which has been produced by the respondent is taken on record. सिर्फ यही तो
हाँ,
लेना
ये दोनों थे।
and it appears that an award of rupees 48.99 acre in the name of Jewel Urao, son of Lugu Urao, and the production of documents so that the award can be so that the amount of the award of compensation can be by a petitioner to approach the District Land Acquisition Officer Ranchi with the documents. And आपके और भी तो legal years होंगे,
He's the only son
नहीं पता ना?
that the petitioner will present
That-
the documents.
It is further made it will be open for them to have their remedies in accordance with it. That's all.
Election
District
one,
petition is accordingly disposed of.
I've also prayed for statutory.
At-
It is pertinent to mention that acquired in the year 2014 and the compensation rate
interest as per the provision of law. It is further observed that the claim of interest, if any, will also be considered by the competent authority as per the law. ठीक है? इसको लगाते हैं. ऐसा नहीं हो कि पुराने रेट से इंटरेस्ट जोड़ने से कम ही पैसा मिले. कैलकुलेशन ठीक से कर लीजिए.
लैंड एक्विजिशन 24-25 के बेसिस पे इनको मिला है.
Yes, madam. What is the provision for payment of interest? Are you there for? This is for NHI?
No need.
Not
State.
Auto mention case item 27 WPL 406 of 2023.
I was not informed that they are going to mention. After mentioning, they came and informed me. Issue will also have been ready, but it was actually of the documents.
You mentioned it without informing the other. You mentioned it without informing the
Not,
other.
I asked you, not that after me mentioning, I told you immediately I informed you. As because it is within a list, not that's why after mentioning, immediately I informed you.
अब मैडम हम देखा नहीं. चलो, I shall show them. अब ऐसे
Either or otherwise, if it is difficult, a date may be fixed on that particular date. It may be. Or I am ready.
डेट हम लोग फिक्स कर देते हैं, फिर पार्टी एब्सेंट हो जाते हैं.
It may be started.
क्या मैटर है जरा आउटलाइन
अच्छा,
बताइए.
मैटर छोटा हम बता दे रहे हैं. 1999 में ये लोग रिटायरमेंट they retired sometimes in the year 1999 under the voluntary retirement. This is the catch. Under the voluntary retirement scheme, they took all the benefits. So thereafter, in the year 2006, after the employees retired, also there was a pay fixation committee which recommended, which was accepted, pay fixed in less than
99 they retired.
99.
So they want that differential.
That difference in the year 2017 they raised a dispute. Also, besides staleness, also it's of retrospective pay revision. But
Those who are not on roll.
not on roll and those who have separated after under the voluntary retirement scheme, there are series of judgments of the Supreme Court which said they have to be treated
It
separately.
is a
They
quietus. Once you accept VRS,
Yes.
it is a quietus.
Yes. The latest judgment is of the year 2023 on this issue, wherein the Honorable Supreme Court said what the normally retired person will get and what the voluntary retired person will get. And the first
That is
judgment
the
is
terms and conditions of voluntary
Voluntary
retirement
retirement,
also.
yes.
It is there in the
yes, and that was the scheme. The
also.
Honorable Supreme Court said that this was the scheme and offer given to you. You accepted to retire. You accepted it, realizing that this is the monetary benefit I am going to get, which is over and above my normal entitlement. And therefore, I agree. This is the only small issue. But document wise, and Lordship, they will be relying on one document. That is in the year 1995. Lordship, there was a letter issued by management saying that the persons who are retiring under the voluntary retirement benefit will be given the benefit of pay revision. But that will apply to a scheme which was prevalent in 1995. They did not retire in that scheme. They retired in the scheme, Lordship, they have brought on record
Another
a
scheme.
Another subsequent scheme of the year 2000 which has been brought on record by them, which is perhaps Exhibit W5.
One
No,
hand
there were two schemes. One
There
was
were,
of,
Lordship, ongoing schemes are coming and going, Lordship, every scheme has a
every
different
scheme is a different scheme.
different scheme.
No, no,
So
no.
unless they show that they retired in a
दोनों शुरू हुआ पता चल गया ना अब कहाँ पर है प्रॉब्लम. हम पर चलिए.
therefore that is the best document they can show. And
20. Sorry, 20 is holiday. Some case has been no, 28 नहीं होगा.
आपका नाम लेके कोई केस फिक्स हुआ मैडम. अब आप ये मत बोलिए कि हमको नहीं पता था रिकॉर्ड.
नहीं ये इसमें थोड़ा टाइम लगेगा, लेकिन और एक जो मैटर वो छोटा मैटर लॉटशिप फिक्स किए थे, एक ही दिन में 215 में दोनों
हाँ,
के
काफी देर तक तो मतलब सुनता है.
10th
Of 2023. This case has been mentioned to be taken out of turn by the respondent. Counsel for the petitioner submits that he did not have any advance notice and therefore he has not been able to go through the case record properly. However, he has given the contours of the matter in 416 employees involved in the present case who accepted voluntary retirement pursuant to a circular issued by the petitioner.
scheme floated by
Pursuant to a scheme published by the petitioner, and after their acceptance of voluntary retirement, there was some circular regarding pay revision, which was given of the quantum of relied upon. कौन सा judgment का citation है?
Yes. जो हम read में भी लिखे हुए हैं सारा
ठीक है, अभी नया रेट है।
Yes, 2023 का ही
हाँ बताइए।
we have stated in paragraph.
Following judgments bracket 2006 bracket close 11 SCC 731 comma bracket accepted, the same becomes full and final, and revision of pay is not applicable for such employees. Considering the fact that a large number of employees are involved in the present case, and the petitioner and that will be taken up at 2:15. So what?
I'll be there.
But somebody else had come in this matter
This
She was previously appointed
as a matter to represent whom?
the work.
workman.
So you also be there. We'll seek your assistance also. Once an amicus, we'll trust you more than both the parties. You will get your homework. The records received be retained by by the learned court master, so that the parties may go through the same. Learned amicus, who was appointed by this court earlier, is also present. This court requests her to get ready with the matter, irrespective of the fact that the counsel for the concerned workmen.
Item 10, WBC 1265 of 2020.
Petitioner? टाइम तो नहीं होगा ना
ये
इसमें?
काउंटर दिया था जवाब देना
क्या चीज के लिए आप
स्टेट का है दिया है
अब बताइए ना, क्या ही देना है? बताइए, आप देखिए काउंटर में क्या लिखा है। आर्बिट्रेशन है, जाइए आर्बिट्रेशन करिए, इसमें करना क्या है आपको? आर यू सर्विंग योर क्लाइंट? Counsel for the respondent has submitted that a counter affidavit has been filed indicating that the petitioner has a remedy as per the provisions of national.
Item 11, WBC 2815 of 2020.
Yes, petitioner.
This case noted by the last order, state was
क्या हुआ
direct.
मैडम?
By mistake से cut हो गई थी, इसीलिए हम लोग भी confuse हो गए. We have asked for, I have asked earlier, लेकिन आज सर्व हुआ है तो इसमें हम लोग rejoinder नहीं डाल पाए. And there was direction
28
to.
अक्टूबर से क्या कर रहे थे आप?
हम
यही सब आप लोग करिए, ठीक है? यहाँ से ऑर्डर कराइए कि ये इसको कॉपी दे दें, वो उसको कॉपी दे दें, यही सब कहानी चलते रहेगा आप लोगों का, नहीं?
And there was direction to measure entire land, and they have a state has measured only a part of them. Today they have given me.
The learned counsel for the parties are present at the request of the counsel for the private respondent. The matter is,
Even the petitioner is also making same prayer.
you are also seeking
Yes, he is also given today
At the-
itself the
at the joint
दिखाना भी है कि ये this was the order, this they have done. You
pose this case on 18th of December. Adjournment 2 साल, 20 साल, 200 साल, 3 ऑप्शन है आपके
हमारे
पास।
पास होता पहले तो हम दिए नहीं, हम कई 2 बार हम बोल चुके थे कि दीजिए.
Item 12, WBC 3082 of 2020.
Petitioner?
Can we see order dated?
My ladyship, I'm praying for not today, my ladyship.
What happened?
My senior's brother had heart attack, so he has to be with him. It may be taken tomorrow, my ladyship, in supplementary.
You want them to construct shops?
So money has been paid.
For-
Agreement
for
was
shop?
executed, yes. For the land below. Actually, they have constructed shop on the land which has been allotted to the petitioners. Now, below they say it is illegal, therefore they demolished it.
2004 Milord, the money has been paid. For one person, Lord petitioner Mama, the agreement was also executed. Now, Milord, now they say, if
The
now,
land
Milord,
belongs to
since
you?
Milord, my daughter is asking
Just
for
a moment. The land belongs to you?
No, it belongs to DVC. Damodar Valley Corporation land belongs to DVC.
Okay.
They wanted to settle the land in favor of the petitioners. For that, the money has been paid, and the agreement for petitioner loan has also been executed in the year 2004. Now they say, different stand they have taken. In spite of the specific direction of this court for the last order, what affidavit they have filed? They have stated the same thing which they have stated in the impugned order. Anyway, my lawyer is asking for time, therefore I cannot object that.
The construction was demolished pursuant to the order passed by this court.
No.
What is the order in CWJC number 1543 of 1998?
That is not for considering the since they have already taken the money for allotment of the shop, allotment of the land.
That order dikhaiye.
That order will not have annexed. It was already after the demolition, the deed was filed.
Kindly have a look at this.
Yes. ये तो पिटिशनर नहीं है, some other case है.
नहीं, क्योंकि आपके इम्प्यूग्ड ऑर्डर में लिखा है, इसीलिए हम आप नहीं लगाए हैं ये ऑर्डर.
नहीं, ऑर्डर के बारे में हमको कोई नॉलेज ही नहीं.
वही ना, अभी आप बोल रहे हैं आपको मालूम है, अभी बोल रहे हैं
so
आपको
far
मालूम है.
this my case below the petitioner earlier came to this court. That order I have annexed.
You just a moment.
ये ऑर्डर के बारे में
Just a
हमको कोई
moment. Page
idea नहीं.
61 देखिए ना, page 61 अपने रीड पिटीशन.
रीड का पेज.
हाँ. वो दीजिए वापस. इसमें मिडिल में इसी केस का रेफरेंस है, इसीलिए हम इस रिकॉर्ड को मंगाए हैं.
अच्छा.
है ना? तो ऐसा तो नहीं है कि एकदम ही अनकनेक्टेड है आपसे.
I was not knowing about this order.
So it
Very
is
frankly,
mentioned in
not
the
answering.
order. It is mentioned in the order. If you do not know, it's your problem. Impugned order में mentioned है, आप बोलते आपको पता नहीं. हमको तो आधा मिनट लगा रिकॉर्ड मंगाने में, आपको हो सकता है 1 मिनट लगता. देख लीजिए. अब आप सोच लीजिए आपको कल करना है कि कब करना है.
देख लेते हैं. नेक्स्ट वीक.
काउंसिल फॉर द पार्टी.
ये मुझे भी ऑर्डर का कॉपी यदि मेरे को मिलता है फोटोकॉपी करके दे दो.
फोटोकॉपी हम नहीं देते, क्योंकि इसमें ऑर्डर था डिमोलिश करने के लिए. उसके बाद सब्सिक्वेंटली केस विथड्रॉ हो गया बाय सेइंग दैट इट हैज बिकम इनफैक्चुअस. मे बी दैट बाय दैट टाइम एवरीथिंग वाज.
उसमें इन लोग पार्टी नहीं था.
हम नहीं जानते. अगर नहीं है तो आप पिटीशन में कहीं लिखते ना कि लोग पार्टी थे, नहीं थे. इट वाज एन एसोसिएशन हु फाइल्ड इट. द एंटायर ग्रुप हैड फाइल्ड इट. कोई ऐसा आइसोलेटेड पिटीशनर का केस नहीं.
एक बार खाली नंबर तो है. ठीक है.
The learned counsel for the parties are present. The counsel for the respondents seek adjournment. However, during the course of argument, it transpired that the order that a reference has been made to the order passed in another petition being CWJC number 1453 of 1998 within bracket R, stating that a large number of unauthorized shops were demolished and new shops were constructed. Counsel for the petitioner submits that he shall examine the records of CWJC number 1543 of 1998 within bracket R. The records have been called for by this court and is directed to be kept along with this file.
इन
आप
लोग का
देख लीजिए
डिमोलिश हुआ 2020 में
हम नहीं जानते
वो
सर, आप
98
देख
है।
लीजिए.
एनीवे आप देख
Post this case on next Tuesday in the supplementary court list. इस रिकॉर्ड का ध्यान रखेंगे, इसको इसके साथ बांधिए और सर को दिखा दीजिए. आप देख लीजिए इसको भी.
एक बार दीजिए डॉक्टर
Item 13, LPC 3558 of 2020.
Petition.
The state is for the private.
This is the award, the certificate case.
Award. In this case, award by the.
Certificate case has also been initiated.
Yes.
Your leadership.
Okay.
Award has been passed by the MSCB Council without recording a finding to the effect that the conciliation procedure has failed. And thereafter, without starting the arbitration proceedings, the award has been passed.
What do you have to say to this?
Lord, we have said
The arbitrator was appointed.
no, the arbitrator was not appointed. Lord. The council itself conducted the conciliation process. Lord,
There
the
is a
affair.
failure report.
Failure. The report has come. The entire record was there.
So where is the failure report? What is the date of the failure report?
Lord, the date, the exact date is not.
Record
23rd of March 2018.
23/3/2018. Read this order.
Lord, it is in the impugn order itself, Lord. 23rd. I am reading from page number 51 of the counter application. Yes.
Counter
Writ
application.
petition. Sorry, writ petition.
51.
Yes.
Okay. 23/3/18.
Yes, Lord. Prior
This
to
is a
that,
failure report. And what is the date of the award?
the date of the award, Lord. This is 26th of May, 2nd of May 2018.
2nd of
May 2018.
23rd.
you just read page 51.
51, yes, ma'am. Decision on 22/2018. Both the parties were present and were heard. The council has directed to issue last notice to the opposite party to submit their final stand on balance outstanding dues of first party for 2,88,144 after receipt of 22,07,359 from the respondent put up on the next. Decision on 23rd of March 2018. Both the parties were present and were heard. Both the parties said that they have cleared their stand and they have nothing to say regarding this case. The hearing was complete and the case was kept for order.
Where is the failure report? Where is the failure report?
A specific failure report is not there.
Forwards. It has to go. Judgment देखे है कि नहीं देखे? देखिए. Judgment देख के कल आ जाइए.
One thing I have to submit before the court, as because after award, the sister company has been acquired by the Tata Airlines. So the right, although the company is not in existence, it is a question.
This company is not in existence.
As because it has
Name
been,
has been changed.
merged.
Name has been changed.
Yes, it is merged in the Tata is still on.
कहाँ है एक बात है और कंपनी का नाम और सील चेंज होना दूसरी बात है. Both are not one and the same thing. The board will change, right? The board can change. Has the name of the company also changed? Shareholders आएंगे जाएंगे, डायरेक्टर आएंगे जाएंगे, इससे क्या लेना देना है?
इस फैक्ट को नहीं लाया गया रिकॉर्ड.
इसको कोई जरूरत ही नहीं है ना लाने का. आप ही बताइए. मुद्दा पर आइए, मेन मुद्दा पर।
एसोसिएट फेलियर ऑफ द कैंसिलेशन
नहीं है ना,
जो नई फैक्ट
इट इज कवर्ड बाय सुप्रीम कोर्ट जजमेंट, नॉट वन पर आपका जो भी कंसिलिएशन का फेलियर रिपोर्ट ड्रॉ होगा, उसके बाद आर्बिट्रेटर का अपॉइंटमेंट होगा, उसके बाद आपका केस डिसाइड होगा। जितना जल्दी करा लीजिए उतना अच्छा। इट इज अ कवर्ड केस बाय सुप्रीम कोर्ट। सब कुछ हम आई नो क्लेमेंट को क्या मतलब है, क्लेमेंट को पैसा चाहिए, कमर्शियल केस है, पैसा चाहिए, और कुछ से थोड़ी मतलब है उसको। सोच लीजिए आपको क्या बोलना है।
हमारा ये कहना है कि कंसलेशन प्रोसेस ड्रॉ हुआ था और 23rd को ही लास्ट ऑर्डर हुआ, उसके बाद फिर
तो देयर इज अ प्रोसेस, फेलियर रिपोर्ट होगा, आर्बिट्रेटर का अपॉइंटमेंट होगा, उसके पास क्लेम फाइल होगा, क्लेमेंट बोलेगा कि हमको और कुछ नहीं बोलना है, फेयर है ना, लेकिन देयर हैज टू बी अ क्लेम, उसके बाद लिमिटेशन, देयर आर सो मेनी थिंग्स इन एन आर्बिट्रेशन प्रोसीडिंग्स। जब कंसिलिएशन होता है तो टाइम बार्ड अमाउंट कैन आल्सो बी पेड, isn't it possible? But in case of arbitration, time barred amount will not be realizable. या जो भी होगा, we do not know what are the nuances. There may be many. That they will do the arbitration proceedings commence, and then they can do it. Certainly they can. There is no legal bar, but there has to be a conscious decision that now they are entering into arbitration, and there has to be two separate proceedings. तो कैसे क्या होगा? ये किसी दिस इज नॉट द सॉलिटरी केस, इसीलिए हमेशा रिकॉर्ड मंगाते हैं ऐसे मैटर्स। तो आपको करना है तो क्या करना है बताइए, आपको देखना है ऑर्डर, देख लीजिए,
हम देख लेते हैं,
देख लीजिए, कल आ जाइए, कल आ जाइए, लेट देम सी दिस।
Yes, the records
इसमें
are
दो
there.
जजमेंट्स है, रिकॉर्ड्स भी आया है,
Records भी आ गया है, I've gone through the
इसमें देयर आर
records.
टू जजमेंट्स।
Yes, one is this. This has relied upon the Supreme Court judgment in the case of JUVNL versus State of
हाँ,
Rajasthan.
JUVNL
वही
वर्सेस
main
स्टेट ऑफ
case है.
राजस्थान, वही मेन केस है। उसके बाद एक और सुप्रीम कोर्ट का केस, झारखंड ऊर्जा विकास निगम एंड गुजरात स्टेट सिविल सप्लाईज कॉर्पोरेशन 23 वॉल्यूम 6401। अदरवाइज 226 में आर्बिट्रल अवार्ड का जुरिसडिक्शन ही कहाँ? In order to exercise the jurisdiction, we have to say it's a nullity. Otherwise, कहाँ से क्या हो, है ना?
because the petitioner has challenged this award on the ground that the composition of the council was not in accordance with the act. But it is there, right? The composition is well within the well as per the
composition वगैरह पे नहीं जाएंगे, क्योंकि composition में और भी issues हैं, नारायण प्रसाद लोधिया और ये सारे बहुत सारे issues हैं।
It is as
The
per
Learned
the
Council and Medium Enterprises Facilitation Council. The Learned Council for the petitioner submits that the case can be disposed of on the sole point that there is no failure report of the MSME Act, and on 23/3/2018 both the parties had appeared and they stated that they have cleared their stand and had nothing to say, is preceded by a failure of the conciliation, and then the arbitration proceeding commences, and only thereafter the award is passed. He has relied upon the judgment passed by Honorable Supreme Court reported in 2021 SCC Online SC 1257, and also judgment reported in bracket 2023 bracket 06 SCC 401, which has been relied upon by this court in LPA number 505 of 2019. इसमें भी तो टाइम फ्रेम दिए होंगे जरूर अपीयर होने के। The interim order granted earlier shall continue till the appeal. आपका तो एक मैटर रिजर्व है ना इसमें किसी पॉइंट पर,
उस पर भी रिटर्न अप्रूवल देंगे।
Item 14, WPC 3662 of 2020.
Yes, petitioner.
Your Lordship, can we see the seventh order, 23rd September 2000?
Yes.
Now, a committee was constituted, Your Lordship, they were supposed to submit the report.
Where is the report? क्या मैटर है मैडम?
They will वहाँ पे 10 फीट भी खोदिएगा तो नीचे कोयला है. The
What
committee
is the committee report? Are you aware?
We have not seen
We
it.
have not seen the committee. Rather, my instructions are, Your Lordship, that when the time fixed by the committee, they did not reach, Your Lordship. So the petitioners were not even present there when this report was.
My instruction is petitioners
There
were
is
there.
no
my
existence of mud or stuff. This is the report.
If I'm दो तीन रिपोर्ट देख लिए थे.
नहीं उस रिपोर्ट का क्या ही करेंगे जब कोर्ट के ऑर्डर से एक रिपोर्ट आ गया.
हाँ वही तो हम जो कह रहे हैं.
If there are contradictory report, then under such circumstances, how a finding can be granted?
3-man committee was appointed by this court. 3 lawyers of this court has gone.
क्योंकि वो जो यहाँ पर पहले भी रिपोर्ट है जो हम लगाए हैं.
See, once there are, after all, if those reports were sufficient, there was no occasion for this court to constitute a committee for that purpose. A committee has been constituted. Photograph के साथ.
At the time of inspection, our officials were there. Petitioners were also there. Petitioners said before the officials of CCL that we don't even know that writ has been filed in our name. I do
ये
not
तो
know
उन लोगों
whether
का
it is mentioned.
सिग्नेचर है पिटिशनर लोग बस रिपोर्ट में.
देखिए तो जो क्योंकि हमको तो जो
My officials have informed me, Your Lordship,
कोई
that
स्लरी नहीं है, कोई खेती है, ये स्लरी हटवाना नहीं चाहते.
स्लरी हटवाना नहीं चाहते
नहीं
हैं.
कुछ भी हाँ यही लिखा है.
तो स्लरी है ही नहीं तो हटवाना
बोल
क्यों?
दोनों ही चीज लिखा है.
दोनों
कोई
ही-
स्लरी बैन नहीं है. आपका पिटिशनर लोग का सिग्नेचर.
matter of fact, in 1999, Your Lordships, when there was a permission given, that was also given wrongly. But one contractor, Sarvesh Singh or somebody, he Lordship took advantage of that, and so the villagers were not even knowing what is happening. Now also the village.
I have filed your Lordship.
Madam, the point is that on view of conflicting report, we can't give a finding.
Well,
So
sir,
that
I
report-
only
You just have a look at it. 4:15 बजे आइए. Next.
नहीं मुझे हमको थोड़ा सा डॉक्टर
कल?
के पास जाना है, कल के लिए कर दिया.
तो आप रिपोर्ट कब अभी देखेंगे? Counsel for the parties are present. A report has been submitted by the 3-man committee, 3-member committee constituted by this court. Counsel for the parties, they are permitted to go through the report, and the matter is accordingly adjourned for tomorrow. Post tomorrow. आप भी देख लेंगे रिपोर्ट. देख लीजिए. Next.
Item 15, WPC 2336 of 2021 along with item 16.
बताइए.
इसमें टाइटल शुड फाइल किया है.
टाइटल शुड फाइल कर दिए तो अब क्या ही बचा है?
नापी से राइट हुआ है. टाइटल शुड में ये भी पार्टी है और इनको नोटिस भी हो गया है.
तो ठीक है, आप जाके टाइटल शुड परसों करिए अपना. The learned counsel for the parties are present. This writ petition has been filed.
फर्स्ट सेकंड नोट्स इट.
For the following relief, the learned counsel for the petitioner has.
He is responding to this case. And in second case, I am the petitioner.
जब टाइटल सूट फाइल हुआ, क्या चीज का राइट टाइटल, इंटरेस्ट, पोजीशन, सब चीज का फाइल हुआ होगा ना. तो बस ठीक है. नहीं नहीं, नॉट टुडे नहीं होता.
Second case,
बिना मतलब के, बिना काम के नॉट टाइटल सूट फाइल हुआ कि नहीं? Whosoever has filed it, how does that make a difference? When right, title, interest and possession is to be determined, then how this demarcation etc. will have appeared?
what has happened, Your Lordship? Your Lordship, in this case, senior advocate Mr. Arun Saha was engaged. That's why I was. Some supplementary में सुन लेंगे.
ये हमारा
कहाँ है आपका
सप्लीमेंट्री एफिडेविट ये है ये
Your
सेकंड केस
case
में
was
429
we were in the
सेकंड केस का सप्लीमेंट
that is covered by my lord's judgment. It's fairly covered.
That's right. अब सूट हो गया है तब वहीं पे होगा ना, अब यहाँ से
इसको कल
Learned counsel for the parties are present. The learned counsel for the private learned counsel for the petitioner in WPC number 429 of 2021 has submitted that the petitioner.
जूनियर डिवीजन 1 हजारीबाग and it is pending.
Just a moment.
सप्लीमेंट्री में
कहाँ लिखे हैं?
हमारा सप्लीमेंट्री फाइल हुआ है
कब फाइल? 29 नवंबर. Eight of 2023.
In which the petitioners are the respondents in this case, my lord, third party.
2336 of 2021 submit that the matter be posted tomorrow as senior counsel Mr. R.N. Sahai has to argue this case, who is not available in this court as of now. Post tomorrow.
Item 17, WPC 4048 of 2021.
Yes, petitioner.
On the last order, may kindly receive your lordship. Time was granted to them to comply with the order dated 9/11/23, wherein the respondent number 3 and 6 were directed to file their counter affidavit, your lordship. But it has been more than a year, but the counter affidavits are not completed, your lordship.
Land has been acquired. Land has
Same
been
matter, your
acquired.
lordship, the adjacent land of the serial number 7, the decision that your lordship has given today, this is the adjacent land, your lordship.
Land has been acquired.
It has been.
What is your counter?
In supplementary counter affidavit, they had stated that.
अभी तो मैडम फाइल खोल रही है, मेरे को थोड़ा टाइम लगेगा समझने में. नहीं पढ़े हैं ना घर में, पता चल रहा. It is visible. You are not aware about your affidavit. क्या लिखे हैं इन लोगों ने?
Your Lordship, ये लोग लिखे कि एक्विजिशन का जब प्रोसीडिंग थे, एग्जीक्यूटिव इंजीनियर को ये लोग चिट्ठी लिखे थे फॉर फ्रेश एक्विजिशन प्रोसीडिंग, क्योंकि पुराना वाला लैप्स हो गया था. और उसके बाद से उसी के बाद फिर एग्जीक्यूटिव इंजीनियर को पार्टी बनाने का डायरेक्शन दिया गया था कोर्ट के द्वारा, और फिर दोनों को, डीसी को और एग्जीक्यूटिव इंजीनियर को काउंटर फाइल करना था, अपने रिस्पेक्टिव काउंटर्स फाइल करना था. बट 9/11/23 को ही ऑर्डर हुआ था, अभी तक हुआ नहीं काउंटर.
They have not filed an affidavit. Yes, why have you not filed an affidavit?
Your Lordship, इसमें एक बार हम coordinate कर लेते हैं within a
कुछ
week.
कोऑर्डिनेट नहीं करना है. अब बताइए किसको बुलाएंगे? अब जिनसे कोऑर्डिनेट कराना है उनको यही बुला. From whom you will seek instructions? Tell us. Yes?
Executive engineer.
एग्जीक्यूटिव इंजीनियर ये क्या करेंगे? ये एक्विजिशन करेंगे.
डेप्यूटी कमिश्नर
एग्जीक्यूटिव इंजीनियर को हम लोग नहीं पहचानते हैं, आप अपने डीसी को बुलाइए. देखिए WPC नंबर 4048 of 2021. In spite of repeated orders, by the order dated 9/11/2023, the respondent number 3 as well as the newly added respondent number 6 were directed to file counter affidavits of October 2024, and the matter was posted today. Today, when the case is taken up, the counsel for the respondent is again seeking time. Apparently she does not. कोई instruction आया आपको?
No, Your Lordship.
She has submitted that no instructions have been received so far. Counsel for the petitioner submits that the petitioner has been deprived of his private land without acquisition. In view of the aforesaid facts and circumstances, the respondent number 3 and 6 are directed to file the required affidavit by Tuesday next, failing which they shall appear before this court and explain as to why the orders passed by this court has not been sequentially, no compensation has been paid to them. Post this case on 5th of December 24. If the affidavit is filed by 3rd December, the state authorities need not appear in person. Supplementary में डाल दीजिए इसको. समझ गया? इस ऑर्डर को आज साइन कराना है. इस ऑर्डर साइन कराना है इसको. हाँ जजमेंट.
Reading for judgment item 1. The LPL there was 795 of 112.
This petition is dismissed.
Item 2. The LPL 5248 of 2019.
Mr. Lai, this is also dismissed.
License.
It will be uploaded tonight.
Since 1986, he is running that business since 2016 without any complaint. And in the all of a sudden, in the year 2016, in personal own Godam, it is not any otherwise. Second thing, license was firstly suspended. Within 7-8 days, it was cancelled. In this case, they have violated the norms. Second, I am suffering, my lord, and this is the order.
2016 you are suffering, you have filed the repetition in 2021.
Can you see? One order can you see?
No.
Just 1 minute, madam, I will certify lordship. This is the arbitrary order, that's why can you see?
There is 30-day limitation.
We will control that.
My lord, can you see? Firstly, my lord, see the annexure 1. In this context, when matter was delayed, application was filed by petitioner, my lord. Kindly see my annexure 1, page 24. This order has been passed by the DC Deputy Commissioner in the year 2016 itself, that the shop may be restored. This is the order, my kindly see. उपयुक्त विषय में रामचंद्र साहू रामप्रसाद साहू पंचायत कमेटी अनुरोध है कि साहू का बंद किए गई जब वितरण प्रणाली जिनकी अनुमति सच है समीक्षोपरांत चालू करने हेतु समुचित कार्रवाई की जाए. This is the order of the Deputy Commissioner. And second thing,
तो आप क्यों नहीं करा लिए वहीं से?
so I have filed my recommendation. That was thereafter. Thereafter, my lord, they have kept this matter pending. This is my humble submission. I am not sitting silently, my lord. I have already. Thing is that, my lord, you cannot pass two order, my lord, saying that there is no allegation against him. I have filed supplementary affidavit in this regard, my lord, as per direction of this honorable court. One judicial order is passed by the honorable court. Filing. So for final form and order sheet, that I have kindly see my supplementary. I have enclosed that document. in FIR, after investigation, final form has been submitted against in favor of the petitioner, saying that no material is there, and that is done, my lord, in the year that was submitted, my lord, in 2016, immediately, my lord, thereafter, after few days. This happened, my lord. How arbitrary they have acted, my lord, this. No, nothing, no irregularity was found. No,
Where is the impugned order?
yes. My lord, can you see an extra 2 months? If you will, somehow your lordship will understand, my lord. Page 25. This is the first order passed by subdivision officer Gumla, Basi. As per which, my lord, the direction was given to one Ajay Tirki, executive magistrate, my lord, to inquire the matter. It is said, my lord, प्रतीति के अनुसार 10 बोरा चावल अधिक दिया गया है, इसकी जांच गोदाम में उपलब्ध आवंटन पंजी संबंधित स्टॉक पंजी से प्राप्त एवं वितरित खदान क्विंटल में मिलान कर लिया जाए. Only this is the direction, my lord. This is the allegation, my lord. This is the allegation, and in the light of that, FIR has been launched, and that FIR has finally.
See, the FIR has ended in final form. It has been accepted by the court also, right? Saying that only when the FIR was also lodged, that case has been dropped. So let the deputy commissioner consider this matter. That should suffice. FIR करके तो आप लोग सो गए. एलिगेशन लगा दिए चोरी का, इसमें लिख भी दिए कि FIR करेंगे, उसके बाद कैंसिल कर दिए, उसके बाद सो गए.
तो उसमें जो आप suspended with license on the basis of irregularity of 10 bags of extra
Yes, only this is the allegation.
grains was found.
And that is the allegation in the FIR.
Who is responsible for that? जिसके पास मिला वो कि जो दिया वो?
इनके पास मिला ये
unaccounted for.
होता है क्या कि ऑनर नहीं बिका, मान लीजिए मेरा गोदाम में सामान आया, लेने वाला नहीं आया, तो वो स्टॉक में रहेगा ही. इसमें क्या इरेगुलरिटीज है? मान लीजिए हमको 50 क्विंटल मिला, लेने वाला 10 क्विंटल का नहीं आया हो मेरे पास, तो स्वाभाविक है मुरवत करता है.
कहाँ है आपका जॉइंट रिपोर्ट?
Page 21, annexure A series.
You may have to say something on this report. What is it?
So there is delay also of 5 years you need to say.
5 years will take.
And there is alternative remedy available.
आप एक रिपोर्ट बनाएं. इस रिपोर्ट को उनको देकर कुछ हियरिंग किए हैं क्या? नहीं किए ना, तो बस रिपोर्ट पे सुनवाई कर लीजिए. इनका FIR ऑलरेडी खत्म है.
एक चीज और मुझे कहना चाह रहे थे, इनका पहले परमिट one judgment I have enclosed with the lordship, annexure 7, page 32. This is the judgment passed by the Honorable Court. What happened, my lord, a decision has been taken by the state of Jharkhand that in respect of suspension and cancellation cannot be done by such authority, my lord. One team should be constituted, and after completion of
ये कमिटी नहीं बनाया तो कैंसिलेशन नहीं होना चाहिए. बहुत अच्छा है.
लेकिन कैंसिलेशन का पावर जब दे दिया गया था, एक कमिटी करेगी इसकी.
करेगी. कहाँ है कमिटी?
देखिए इसमें जजमेंट है.
जजमेंट का आप हमको बताइए ना, कौन से कमिटी के पास भेज देते हैं उसी के पास.
ये नहीं कहना चाह रहा हूँ.
That committee does not exist, no? Does it exist? Tell us. Is there any statutory provision for committee?
My lord, only my lord, one line, one paragraph placed lordship, page 33.
Yes.
He submitted that the government of Jharkhand by order number 65/2005, my lordship, can you page 33?
Yes.
Directed that authority concerned to constitute a committee in every district of the state of Jharkhand under the chairmanship of the concerned deputy commissioner. But even though, my lord, in my matter, no notice, no show cause, nothing arbitrary, that took, my lord, can
He says that the committee has already been constituted.
That is
in
the
which
reason.
3 authorities
Yes,
are included.
Yes, madam.
And this has to be headed by the deputy commissioner.
Only. How he has acted upon. Second thing, my lord, your lordship, no, my lord. If suspension, my lord, when suspension was done on 28/6/16, and cancellation was done on 5/7/16. within 10 days. This shows, my lord, how they have conducted against this petition. Any complaint was passed against him, filed against him.
देखिए WPC number 4318 of 2021. This stated that the petitioner was having fair price shop by license number 17 of 1985. Letter dated 21/5/2016. It was alleged that 10 bags of rice was found in excess in the premises of the petitioner, and was also suspended.
Quickly suspended.
Was suspended by the said letter and subsequently cancelled by order dated
5/7/16.
5/7
Next year 3/1, my lord. Next year 3/1.
5/7/2016. The learned counsel submits that the FIR in the criminal case, the final form was submitted and it has also been accepted by the concerned court. For this purpose, he has filed a supplementary affidavit dated 8/9/2022, and the final form was accepted on 2/8/2019 by the concerned court. The learned counsel submits that the impugned order of cancellation of license has been passed by the subdivisional officer Basia, and he made representations before the deputy commissioner as contained in Annexure 6, but having no response, the present petition has been filed. He has also relied upon a decision on 16/6/2005 that any decision in connection with issuance of license, suspension, revocation and cancellation under public distribution system will be taken by a committee headed by the deputy commissioner on the recommendation of the subdivisional officer. He submits that the decision in the present case has not been taken by the committee, and the representation filed before the deputy commissioner has also not been disposed of. The learned counsel, appearing on behalf of the state while opposing the prayer, has submitted that the acceptance of final form in the criminal case has no bearing in this matter. The PDS license was cancelled after conducting an inquiry. The inquiry report has been annexed as Annexure A series to the counter affidavit. However, during the course of hearing, he has fairly submitted. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the license of the petitioner has been cancelled by subdivisional officer, and by virtue of order passed by the subdivisional officer dated 21/5/2016, An FIR was also executed, but ultimately the final form was submitted and which was also a decision was taken by the state government by the order dated 16/6/2005 that the matter regarding issuance of license, suspension, revocation and cancellation under PDS system will be taken up by the committee headed by the deputy commissioner certainly on the recommendation of subdivision officer. Admittedly, in the present case, the cancellation of license has not been done by the committee, and in spite of representation having been made by the petitioner before the deputy commissioner against the cancellation of license, no action has been taken by the deputy commissioner.
One thing, nature one illusion.
This court finds that the cancellation of license of the petitioner is not in accordance with the order issued by the government dated 16/6/2005, and therefore the same cannot be sustained in the eyes of law. Annexure 3/1 is hereby set aside on this sole ground. The petitioner has already represented before the deputy commissioner by representation dated 28/2/2021 the essence of the petitioner in view of the fact that there are allegations against the petitioner. The representation of the petitioner is directed to be considered by the committee constituted under the chairmanship of the Deputy Commissioner Gumla. The petitioner to appear before the Deputy Commissioner on 11th of December 2024 at 11:30 a.m. The subdivisional officer, SDO है ना? SDO shall also appear before the Deputy Commissioner on the same date along with the connected records. The petitioner shall also produce a copy of the records of this writ petition accompanied with a detailed representation. Upon appearance before the Deputy Commissioner, the matter be placed before the committee, who, after granting an opportunity to the petitioner and also the subdivision officer, and upon going through the record, shall pass a reasoned order within a period of 15 days. Reasoned order by 24th of December. The reasoned order be communicated to the parties.
Just one clarification. During the course of inspection, he was given an opportunity, but after joint report, no hearing was done.
Counsel from the respondents has submitted that during the course of inspection he was given an opportunity, but no opportunity was given to the petitioner after preparation of the report. अब तो मिल गया है, अब तो रिपोर्ट मिल गया है,
नहीं
रिपोर्ट मिल गया ना आपको?
काउंटर के आधार पर मिला है,
जो भी अब तो मिल गया ना?
काउंटर के आधार पर मिला है।
Yes. Since the report has already been placed on record by the respondent through the counter affidavit, it will be open to the petitioner to respond to the report in his representation. ठीक है? उसका भी response अब फाइल कर लीजिए। आपको जो भी फाइल
that cow has eaten the grains.
चलिए।
Item 19, the European 5620 of 2021 along with item 20 and 21.
Yes, petitioner. क्या चीज़ के लिए आपको टाइम चाहिए?
Dr. Asok Kumar Singh out of West.
Huh?
Dr. Asok Kumar Singh out of West.
What is the matter?
Lord, only single issue is available in the present case. The appropriate government annexure 6 page number 27.
कब का dispute है? It's an order of dismissal.
Yes, ma'am. Order of dismissal.
What is the date of dismissal?
Dismissal date is ma'am 14 to 1998. I'm around the
14 to 98.
yes.
सबका same है? अच्छा okay. 14 to 98. When was the dispute raised?
In the year 2016, my lord, the disputes were raised, and the rejoinder was also filed, my lord.
What is the reason for delay?
My lord, the
How many
petitioner
years
was-
delay? 8 years.
Yes, my lord. Since my lord, the reason that my lord, the workman was seriously ill, my lord, and he was unable to appear before the my lord authority to do his services, my lord, and they are just dismissed the workman without
No,
issuing.
no, no. Delay. 98 के बाद क्या किया? 98 के बाद भी बीमार थे?
No. But my lord, we have represented before the authorities, my lord, in the year
Representation is
2000.
not a ground.
But my lord, I am only on the point, my lord, that reference has to be made to the court or the court, my lord, without entering into the merit, my lord.
They have entered into the merits.
Yes, my lord. Kindly have a look to the, my lord. Only point, if the dispute is there, my lord, it has to be referred to the court or the court, my lord.
Show me some judgment on
Yes,
this.
my lord. There is a
When the
judgment, my lord.
dispute. From where do you say that the dispute is
My
existing
lord, they
and
are
not a
saying that
state?
there is the dispute is not amount to consideration, my lord. Kindly have this judgment.
No, no. Judgment बाद में पहले ये order पढ़ी.
Yes, I am directed to refer the failure of conciliation report number so and so received in this ministry on 16/7/2018 on the above mentioned subject, and to say that prima facie this
कब
ministry,
आएंगे आपके सीनियर? ये सब क्या है?
my lord, this ministry does not
ये मेरिट पे तो जा ही नहीं सकते ना.
Next week.
my lord, they are saying that this dispute is not subject to consideration, my lord. So they are admitting that there is a dispute. They have to only refer before the court. Judgment, my lord, of the Honorable Supreme Court says that, my lord, they are not required to enter into the merit of the case.
कौन ये BCCL कौन ये Annexure 4? नहीं, Annexure 4 is the Annexure 4 is not the impugned order. Which is
Annexure
the
6,
impugned
my
order?
lord. Annexure 6, page
आप
27.
Annexure 4 की बात नहीं. Annexure 6 के बारे में पढ़िए जरा.
Page number 27, my lord.
27.
Ministry of Labour and Shram Mantralaya.
आप तो क्या ही किए हैं, इतना सारा टाइप कॉपी फाइल कर दिया. ये सब क्या है इतना सारा? आपका पिटीशन का फर्स्ट कॉपी किधर है?
WPS 5620.
ये स्कैन कॉपी फाइल हुआ था. आपका फर्स्ट कॉपी कहाँ है? 27 पढ़िए जरा.
Yes, Ministry of Labour and Shram Mantralaya. Sir, I am directed to refer this failure of conciliation report number so and so received in this ministry on 16/7/2018 on the above mentioned subject, and to say that prima facie this ministry does not consider this dispute fit for adjudication for the following reason. So they are not considering.
आगे पढ़िए.
The Jharkhand Colliery Shramik Union raised the issue on 5/2016 relating to dismissal of Sri Bajnath Mahato, ex-Eugene Manor Rotor, by order dated 14/2/1998 by the management of Madhuban Colliery under Barora area number 1 passage of 18 years from the cause of action without explaining the tangible reason of such an inordinate delay. As such, the IT is highly belated. In this connection, the judgment of Supreme Court in Nandungadi Bank Limited versus so has held that a dispute should be raised within reasonable time. Lord, I have also a judgment, my lord. They are admitting that there is a dispute. Without referring, my lord, despite referring the matter to the court or the court, my lord, they are deciding the dispute by their own. And they are saying that,
How they have decided the dispute?
my lord, they are saying that the dispute is not fit for adjudication. So they are not, my lord, they are only required to refer the matter to the court. They do not have the jurisdiction
Are
to
they
decide
post
the
office?
dispute.
Are they supposed to behave like post office?
Lord, there is a judgment of Honorable Supreme Court.
कहाँ
Kindly have a
लिखा है ये
look, my lord.
judgment
Yes,
लिखा है? कौन सा judgment लिखा है? That they have to act as a post office. फिर क्या ही के लिए होता है reference? आपको dismissal हुआ ना? 2A में क्यों नहीं गए?
My lord, that dismissal is also under challenge, my lord. That dismissal, my lord, no
2A में
procedure
क्यों
was
नहीं गया है?
followed.
Why not under 2A?
Yes, ma'am. Page 21 paragraph.
Yes.
In view of the above, law can be summarized that there is no prescribed time limit for the appropriate government to exercise its power under Section 10 of the Act. It is more so in view of the language used, namely if any industrial dispute exists or is apprehended, the appropriate government at any time refer the dispute to a board or the court for inquiry. The reference sought for by the workman cannot be said to be delayed or suffering from lapse when law does not prescribe any time limitation for raising a dispute under Section 10 of the Act. The real test for making a reference is whether at the time of reference dispute exists or not, and when it is made, it is presumed that the state government is satisfied with the ingredients of the provision. Hence, the labor court cannot go behind the reference. It is open to the government to go into the merit. It is not open to the government to go into the merit of the dispute concerned. And once it is found that an industrial dispute exists, then it is incumbent on the part of the government to make reference. It cannot be itself decide the merit of the dispute, and it is for the appropriate government of forum to decide the same. The satisfaction of the appropriate authority in the matter of making reference under Section 10 of the Act is substantive satisfaction. Normally, the government cannot decline to make reference for lapses committed by the government. If adequate reasons are shown, the government is bound to them. So, my lord, they are not authorized to go into the merit of the case. The only thing that will be decided by the court or the board, they are only required to refer the matter to the board or the court. No time limit is there, my lord. Once a dispute, my lord, it is stated that if the dispute is arising, my lord, that has to be referred to the board. Board will decide, my lord. They have decided by their own. As per Section 10 also, my lord, reference has to be made to the court or the court by the appropriate government. So they are saying that the dispute is there, my lord. Dispute is existing. So despite referring the matter to the board, they have decided by their own, without the jurisdiction.
Where is your application for ALC?
And except fee.
Annexure?
Annexure 3.
3 में क्या है?
Lord, against dismissal we have prayed for, my lord, reconsideration of law.
No. Where is your application filed before the Assistant Labour Commissioner?
Lord, Annexure 4 is the written statement given by the management before the Industrial Dispute Authority, my lord. We have also Annexure 5.
I am asking your representation. Where is that?
Annexure 5 is the rejoinder, my lord.
Where is your petition?
Petition is not annexed, my lord.
Very good.
But there is no dispute, my lord, that the application is not filed. They have filed the written statement, we are annexed. We have also filed the rejoinder, we have also annexed that one. So written statement and rejoinder is.
Your application would have disclosed what is the reason for delay. Where is it?
Only contention, my lord. If at all, my lord, there is a delay, that will be decided by the board.
आज एक जजमेंट अपलोड होगा, देख लीजिएगा, फिर कल आके जजमेंट। ये जितना भी जजमेंट है सब कंसीडर्ड है, इसमें कहाँ लिखा है? गया?
That at all there is a dispute, my lord, and there is no time limit fixed. The appropriate government has to refer. The only thing required is the dispute.
They also say that they do not have the official records to verify. Para number 7. Para 6 and 7. Right? Annexure 4, page 22.
The workman was the permanent employee. We have given in the rejoinder, denying all the contention made by the management. Every contention they have raised in their written
They
statement.
say they do not have the records. Then what denial have you
That is
given
not
to
in
them?
dispute that I am not the workman.
Suppose it is held that the action was not in accordance with law, right? They will have to produce evidence. You will also have to produce evidence. ये 1998 का evidence management कहाँ से लेके आएगा? समझाइए? Therefore, today one authorized.
But there, on the one hand, they are saying that they do not have any record.
No,
on the other hand, they have issued the
जिसका
dismissal
उनके
order.
पास है, जिसका बारे में वो है, आपने डॉक्यूमेंट्स लगाए होंगे, इसीलिए तो आपने मेन पिटीशन नहीं फाइल किया.
That will be filed, my lord. But they are saying that the record is not their own record, my lord. The
They
documents.
say that
And they are
this is not
dismissing
there.
the workman, my
They
lord.
say that the contention of the union is subject to production of documentary evidence for the same. That this contention of the union again depend on document.
My lord,
There is no
it is
official record to support this claim
My
of
lord,
the
it is
union.
self-contradictory, my lord. Para 3 they have stated, my lord.
We'll see that. ये तो टाइम ही मांग रहे हैं, इनका
My
कुछ
lord,
क्या ही
para
कर
3
सकते
they are saying that they have issued so charge sheet. They have issued so called charge sheet, my lord, without document, my
Counsel
lord.
for the parties are present. All these 3 repetitions arise. In all these 3 repetitions, the issued order is refusal to refer the dispute for adjudication by the competent court/tribunal. Counsel for the petitioner has relied upon judgment passed by the Honorable Supreme Court in the case of Kuldeep Singh versus GM Instrument Design Development and Facilities Center and another report in SLP Civil number 4137 of 2007, and has submitted that by the issued order the authority has gone into the merits of the dispute, which is not permissible under law. In particular, he has referred to paragraph 21 of the judgment. Counsel for the respondent pay for time pose these cases under the heading for final disposal on Monday to be taken up at 2:15. No further adjournment will be granted.
In a matter that will be listed tomorrow in the supplementary list, I have a reply and that is being filed.
File it.